hearing docket this morning. We have Mr. Stewart with the state via Zoom. Good morning.
Good morning, Your Honor.
And we have Ms. Armpriester with the Public Defender's Office. Good morning. All right, let me go to Mr. Casassa. Good morning.
Good morning, Judge. How are you?
I'm doing well.
Good. Judge, this is on Bella Joseph.
All right, case number 19 CT 1325.
Judge, this was originally couched as a motion to clarify and a motion for early journal. I understand from probation that he hasn't. There's now some outstanding conditions, so we're just proceeding now on the motion to clarify.
Okay.
Judge, Mr. Joseph is Haitian. He does speak English. It's not the greatest English. And in any event, he did a victim impact panel, but apparently he didn't do the one that probation had told him to do. I think Mr. Hornbuck has a certificate of the one he completed, and within the court's discretion, we're asking if you would consider this victim impact panel instead of the one that he was. I guess he's supposed to do one through Mad Mother. Which one did you do, Mr. Hornbuck?
SBC Victim Impact Panel, Houston, Texas. I don't know who this is. Would you like to see it?
Yes, please.
Judge, since the pandemic, I've run into this a few times where people do things online. I don't know that they're deliberately not doing the proper one, but they're. One thing, Mr. Joseph is a regular in the system.
I do have some things to say when you're ready.
All right. Well, let me ask you, Mr. Hornbeck, did you reach out to this SBC victim impact panel?
We did this morning. It's got
They're probably not open yet since they're in Texas.
right.
What's the state's position?
Judge, well, for starters, I haven't seen the certificate or document that's being referred to. It wasn't attached to the motion, so I'm not familiar with what it says or the nature of the program. I think perhaps we're going to need more information on the program, and if it's an equivalent to what is typically done here, then I don't necessarily have a problem with it, but we're kind of flying blind, and I don't know until we have more information if we can really say if it's adequate or not.
So just to clarify, that's the first time I've seen that.
Okay.
As well.
All right. Mr. Hornbeck, anything you?
Well, Your Honor, my orientation, I did tell him which one to do. I did give him the website to go to. And then at least when they do the MAD one, Mothers Against Drunk Drivers, they do take a photo of them to show that it was them doing it. So I don't know that he did that. I understand it has his name on it, but it doesn't mean that he did it. At least with the MAD, which is online because of the pandemic, they do have to take a photo while they're doing it.
Well, Judge, the only thing I would say about that is that applies to lots of the things that the court requires.
Right.
I don't think the court orders that you have the photo taken while they take the class. And while I understand technically it wasn't the one probation told them, there is a little bit of language discrepancy.
Right, sure. So I think the court would feel more comfortable if we knew more about this victim impact panel before ruling on the motion.
Well, perhaps probation can make a couple copies. I'll take one to the state. I will have one as well. And then we can give the court some more information, see if the state has any objection.
Okay, I think that's a good idea. So I'll reserve ruling on the motion to clarify, and we'll consider the motion for early termination withdrawn.
I will see if I can get everything done by the time we clarify all this.
Okay, all right. And then if both parties agree, just send the order to my judicial assistant. If not, then we'll come back in and address it.
I appreciate that, Judge.
Okay, all right. Thank you, Mr. Casassa.
Okay.
You too.
Yes, sir. Well, thank you. I'm going to see James now, so I think. See you, Greg.
All right. All right,
Good morning, Your Honor.
Good morning.
I'm here on behalf of James Lausch, State v. Lausch 21 MS 122.
All right.
It's the state's motion for medicals, Your Honor.
Yes. Mr. Stewart?
Yes, Judge. Pulling it up right now. This is an investigative case from Florida Highway Patrol, and Ms. Karimi did attach a probable cause narrative to the motion. It is sworn to, and I believe it lays out at least the bare minimum for the fact that the records sought here are relevant to an ongoing criminal investigation.
Objection, Your Honor.
Okay. Go ahead with your objection.
No legal basis, the record of Mr. Lausch.
Give me one moment here. All right, well, having probable cause affidavit, I do find that there's a nexus between the investigation and the state's request. So I'm going to grant the request for the, I'll grant the motion for leave to subpoena medical records and EMS records and discussion of communication with medical professionals as it relates specifically to any intoxicants. Mr. Stewart, do you have a proposed order?
Judge, I will email one to your judicial assistant. Who's the attorney that appeared on Mr. Lausch's behalf?
Rick Mangone?
Mr. Mangone. Okay, I'll make sure to copy him on that.
All right, very good. All right, thank you, Mr. Mangone. All right, let me go to Mr. Hopkins. Good morning.
There we are. Okay. Good morning, Your Honor.
Good morning.
Your Honor, this is the defendant's motion to issue subpoena ducis tecum on State v. William Barber, B-A-R-B-E-R 21 MM 499.
All right.
Your Honor, in this case, it involves two batteries. The battery, and what the court will see from the probable cause affidavit, the battery is, or batteries are alleged to have occurred at Mercado, outside of establishments, just from personal knowledge and experience from previous cases. I know there's surveillance video at Mercado. Our office has spoken to one individual who was identified as a female individual. I think that's what led to the altercation with the bouncers that led to the charged offenses. She has made statements that contradicts what's contained in the probable cause affidavit. So obviously the video would be the best evidence to show exactly what occurred. That's my reason for seeking the video evidence if it exists.
All right. Mr. Stewart, does the state have any objection?
No, Your Honor.
All right. Motion to issue defense's subpoena ducis tecum for the video footage at Mercado is granted. Mr. Hopkins, will you send the proposed order to my judicial assistant?
Yes, Your Honor, I will, after the state reviews.
All right, very good.
Thank you.
All right, thank you. Let me go to Mr. Fayette. Good morning.
Good morning, Judge. Can you hear me?
Yes, I can hear you. Can you hear me okay?
Yes. Judge, I don't have any legal basis to object to the state's motion.
This is on Hudson Reeves, 21 CT 177.
Yes, Judge, it was the state's motion, and I know Ms. Karimi referenced the probable cause affidavit, which is part of the court file. So I can, the court grants it, I will send your judicial assistant an order and copy Mr. Fayette on that.
All right. All right. State's motion for leave to subpoena medical records, CMS records, and authorizing discussions with medical professionals is granted.
Thanks for your time.
All right. Thank you, Mr. Fayette. All right. Let me go to back to the courtroom here. Good morning, Mr. Chandler. And we're here on William Coet, case number 20 CT 2503. I'm doing well. How are you, Mr. Chandler?
Sorry, not right.
Yes, right. All right, we have Mr. Coet approaching.
Yes. Says change the room this morning.
All right.
This is the center for the withdrawal precinct, please, not to be no contest on count of DUI or 5. The terms of the agreement are adjudication for the $1,000 fine, 12 months of supervised county probation, and early terminated after 6, 12-month driver's license suspension. I don't believe the state would have any objection in the hardship. You have to apply on that. The DUI school appropriate phase of the evaluation of all recommendations random testing does include the 6-month conviction interlock, no alcohol, no bars, showers, etc. For the alcohol, 10 days vehicle mobilization, service hours, the impact panel, plus investigation, or costs. I'm sorry, call for prosecution. Learning.
All right, Mr. Stewart, is that offer correct?
Yes, Your Honor.
Does the state have any objection to Mr. Coet obtaining a hardship license?
No, Your Honor.
All right, the court has no objection either. All right. Sir, will you raise your right hand to be sworn by the clerk?
I do.
Will you state your name?
William P. Coet.
Mr. Coet, what's your date of birth? And your attorney has indicated that you wish to withdraw your previously entered plea of not guilty, enter a plea of no contest, and accept the state's offer to resolve your case today. Is that correct?
That is correct.
All right. And did you hear the offer placed on the record by your attorney?
Yes, sir.
Do you have any questions about it?
No.
Do you want to accept the offer?
Yes, I do.
Are you pleading guilty or no contest?
No contest.
And I have a plea form in front of me. Is this your signature on this form?
Yes, sir.
And by signing it, you've indicated that you've read it or it's been explained to you?
Yes, sir.
Did you understand all of the rights listed on this form?
Yes, sir.
And you understand that you're waiving your rights by entering your plea today? You understand that your plea will be used against you in a deportation proceeding if you're not a United States citizen? Are you under the influence of drugs, alcohol, or medication?
No, you're not.
Have you ever been diagnosed with a mental illness?
No, you're not.
Are you satisfied with your attorney's advice? Has he done everything that you've requested?
I'm sorry.
Has he done everything that you've requested? Do you understand that driving under the influence is an enhanceable offense, meaning if you're convicted of this crime in the future, you could be facing higher fines, higher penalties, more jail time, longer loss of a driver's license, or a possible felony offense.
Yes,
And knowing that, you still wish to enter your plea?
yes.
All right. Mr. Stewart, any additional questions from you?
No, Your Honor.
Mr. Chandler, will you stipulate to venue and the factual basis for the plea?
I will.
All right. Sir, I'll accept your plea. Find it knowingly, voluntarily, and intelligently entered upon a factual basis and in your best interest, adjudicate you guilty, sentence you to 12 months of probation. You may apply for early termination after serving 6 months, provided all conditions have been satisfactorily met. The court will impose a $1,000 fine, all court costs, including costs of prosecution. There will be a 12-month driver's license revocation. The court has no objection to you obtaining a hardship license pursuant to DHSMV procedures and policies. You must complete the appropriate DUI school, 1 victim impact panel, 50 hours of community service, a 6-month ignition interlock, a 10-day vehicle impoundment. You must undergo a substance abuse evaluation, follow all recommendations, and you'll be subject to random testing at your own expense. There will be a no alcohol provision. That means you cannot consume alcohol while you're on probation. You cannot possess alcohol. You cannot have alcohol in your residence. You may not go anywhere that primarily sells alcohol, such as bars, taverns, saloons, or packaged liquor stores. And you must report to probation today before you leave the courthouse. It's located on the 1st floor. All right? All right, we're gonna have you step right over here to be fingerprinted. Thank you, Mr. Chandler.
Good to see you.
Nice to see you. Give me 1 moment to review that. Can you put it on the other, what's that?
I hear it's been having issues.
You have another screen that it can go on? Because I see a cat.
Yeah, that's an issue.
It's not talking.
I'm not sure how to fix that, but I hear that that's been an issue lately.
Huh.
Have to email office to see if our IT department.
Okay.
Right, and Ms. Armpriester, is that your client in the courtroom?
No, she's looking.
Oh, okay. All right, let me go to Mr. Lucarelli on Zoom.
Can you hear us, Judge?
Yes, I can. Can you hear me okay?
It's fine, thank you. Good morning.
Good morning.
Wayne Gagnon, case number 21 MM 378. We continued from the last time we tried to do this to return his weapons. Motion to return his weapons, but we needed some proof. These are weapons that he inherited from his father, Judge. He turned them in after his arrest. And I've filed the only documents that we could find that would indicate any kind of ownership. One of them being a safety inspection certificate.
All right. Mr. Stewart, what's the state's position?
Judge, the state's position is, well, obviously the case is dropped, so, and I believe these were seized pursuant to the, not necessarily the arrest, but the, him surrendering his firearms as part of the first appearance court order. So I am not aware of or haven't been made aware of any sort of ongoing investigation that would necessitate these firearms being held, and if these are the ones he surrendered as part of his as part of the court order, then I would presume he had them in the first place. So I don't have any reason to object.
Could have just said no objection, James.
Well, that would be too easy, Dominic.
All right, motion for return of property is granted. Mr. Lucarelli, will you email a proposed order to my judicial assistant and make sure that it's specificity, the firearms and that are to be returned.
I've got one prepared already, Judge. If you don't have one, I'll make sure we get you a copy.
All right, very good.
Thank you, Your Honor. Have a good
All
day.
right, Mr. Lucarelli, you too. Let me go to Arm Priester. Good morning. And just do we have Mr. Justice here? We were bringing him over in case you needed to take testimony from him.
Do you have our inmate justice?
You want to do that one first?
Sure.
All right, Jack Justice, case number 20 CT 310 with Ms. Arm Priester. Good morning.
We're here today for a motion to set bond on Mr. Jack Justice, therein Priester on his behalf, specifically in case 20 CT 301. Your Honor, the burden of proof in a motion to set bond is if Mr. Justice does or does not participate in whether or not he is flight risk. If it pleases the court, may I please take testimony of Mr. Justice?
Yes, you may. Mr. Justice, will you raise your right hand to be sworn by the clerk?
Do you swear or affirm that the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
Yes,
Sir, can you please state your name for the record?
Jack D. Justice,
And where do you reside?
36 Avenue, in Peace.
Reside in Sawyer County?
Yes.
And how long have you resided in Sawyer County?
Approximately 11 to 11 years.
And are you able to work?
Yeah,
How do you pay your bills if you live your lease?
I love this building.
And do you have other family in Sawyer County?
Yes, my wife.
And do you have support in your life? More financial household?
More owners.
And do you attend any local community centers or churches? Do you have an outside support system of friends that you and your wife are involved
Friendships.
with? And you don't have any family out of state?
No.
You're aware that you're currently in custody on a violation of probation?
Correct.
And can you explain to the court what intoxicant you were alleged to have been under the influence of the night that you were arrested?
Okay.
No, that's what you were alleged to. What substance?
Oh, I was on a prescription Tramadol
And why did you take Tramadol?
for getting my knees out of the work.
And who gave you that Tramadol?
Honestly, I never knew the name. Prescription bottle.
But it was a medical provider?
Yes,
And did you take a sleep aid that night?
yes, I did. Couple.
Had you consumed any illegal intoxicants that night?
No.
You understand you still have to complete many sanctions of probation.
Yes.
And is it your intention to, if the court sets on, to complete those sanctions?
Yes.
I have no further questions.
Mr. Stewart, any questions?
Yes. I'm sorry, Mr. Justice, I couldn't hear everything you said. Did you say you were under the influence of tramadol on this evening?
Correct.
And you're prescribed tramadol?
Yes.
And how much had you taken that evening?
I believe 3.
Okay, and how many are you supposed to be taking?
2, I think, is pain is needed, or it needed with pain.
Okay, and had you been consuming any other substances?
Nothing illegal now.
Okay, had you been mixing this with alcohol?
Yes.
Okay, and how much did you have to drink?
That was part of some ice cream. It had some homemade chocolate liqueur.
You had some homemade what? I'm sorry?
It was homemade chocolate liqueur ice cream.
Chocolate liqueur ice cream?
Yeah.
Is that something you can buy at the store, or is that something you have to make yourself, where you add liquor to the ice cream?
It was something that we made late last year.
It was something you made last year? And what kind of liquor did you put in there?
Liqueur.
Okay, and is that, I don't know enough about it. Is that like vodka, or is that, what type of liquor is it?
It's a coffee liqueur.
Okay, and how much goes into the ice cream?
No, because it was made last year.
You don't remember?
No, I didn't. No.
Okay, do you have a good memory of this night, or were you a little bit out of it?
I have somewhat of a spotty memory of me.
Okay, would you agree with me that it's probably not the best idea to mix your medication with alcohol?
Yes.
Okay. All right, Judge, I don't have any other questions.
Follow-up question?
When you had that ice cream, did you know at the time that you were eating the ice cream with liqueur in it?
I was going for taste.
That doesn't answer my question. When you were eating the ice cream, did you know that it was the liquor ice cream?
Yes, afterwards.
Afterwards, but before you ate it, did you know what you were eating?
Well, I mean, he made the ice cream.
Based on a prior conversation, there's more to it, but regardless, we're running anything. No further comments.
Okay, go ahead.
Judge, regardless of the liqueur and the ice cream, the defense's position is that that was a mistake, something that we can defend at hearing. Mr. Justice still is entitled to a bond. He has DUI school, a substance abuse evaluation, service hours, impound and victim impact able to do. He has not yet completed those because of finances. While there still is the issue of the DOP, and he has served quite a bit of time in jail at this point, I would ask that an appropriate bond be set so that he can continue his other sanctions, regardless of any backsliding or slip up or mistake. Mr. Justice is humbly requesting that a reasonable bond be set so that he may complete his probation. Thank you.
All right, thank you, Ms. Armpriester. Mr. Stewart?
Your Honor, he'll have to complete a lot of those conditions even after he's off probation if he wants to get his driver's license back one day. So I don't think that's a reason to release him on bond. My concern, obviously, is he's on probation for a DUI second offense. There was a fairly high breath alcohol in this case. I'm sorry, Judge. And he does have a prior from 2009. Also on his driving record, it indicates, I don't see a conviction, but that he had a breath alcohol above 0.10 back in 1993. So there's obviously a substance issue, which I think continues to persist based on his testimony. So he's not entitled to a bond at this stage in the case. So I would ask the court to maintain the no bond that was previously entered.
All right, based on the facts of the case, the history, and the testimony of Mr. Justice here today, the defense's motion to set bond is denied. Ms. Armpriester, can you prepare a proposed order? That'll be fine. All right, where are we set with Mr. Justice's case? June 15th at 10 o'clock, is that correct? Mr. Justice, hang on, we're not done.
What was your question?
Are we set for a status or a hearing on June 15th?
I believe we're set for a status.
You want to change that to a hearing?
No.
Okay.
Mr. Stewart, I don't see an offer to resolve. Would you mind sending me one, please?
Yes, it looks like the offer is 180 days credit for all time served, suspend 30 days upon successful completion of project recovery.
Okay, I'll be able to talk to you about that.
Okay. All right. So next court date is June 15th at 10 o'clock for status. Thank you, Mr. Justice.
Bye, John.
All right. Next case, Ms. Armpriester.
Judge, next it's not my motion, it is the state. Linda Marie Hart, 20 MM1941. I did attempt to reach out to her to inform her of this, but I was not successful.
Okay. Mr. Stewart, motion to revoke bond, I believe.
Yes, Judge, that was the state's motion. She is out on bond for theft here in Collier in this case, and less than 2 months after she posted bond, she was charged with another theft up in Lee County from January. Ms. Karimi did attach a probable cause affidavit to her motion. So based on the fact that the defendant, there's probable cause the defendant committed a new law offense, actually the same one, while out on bond, the state would ask the court to revoke her bond in this case.
Response, Ms. Armpriester?
Yes, Your Honor. The only argument I have is that Ms. Hart does have a defender on both her cases. It doesn't appear that she has not appealed for her court date. This motion does come about 5 months after the subsequent offense. Bond could have been revoked at first appearance, however, it wasn't. I would argue that at this point it's a new issue as she is in touch with her attorney and handling her cases while on the outside, and we request that it stay that way.
Well, I don't think there was a first appearance, which probably is why she received the notice to appear.
I stand corrected.
Which is probably.
Could have fixed that. I must have misread the note. Your Honor, I still would argue it could have been around for 5 months, even with a notice to appear.
Anything else, Mr. Stewart?
No, Your Honor.
All right, motion to revoke bond is granted. Bond to be revoked in case number 20 MM1941. Mr. Stewart, you'll send a proposed order.
Yes, I will, Judge.
Thank you. And I'll note that Ms. Hart still has outstanding warrants in, I believe it was Tennessee. Yes. Okay. All right. Next case is Joseph Lehman, case number 19 CT 1849. Yes. Yes. All right. Thank you. All right, Mr. Stewart, Ms. Armpriester just handing me an order denying the defendant's motion to set bond. It says denied, bond to remain at no bond. All right, so we're on Joseph Lehman, 19 CT 1849, defense's motion to depose state's witnesses.
Yes, Your Honor. Carrie Armpriester on behalf of Mr. Lehman, I did not ask him to be present today. Judge, I humbly bring this motion before the court. I know it's a very old case. I know there's been numerous attorneys on it. As the court and the state is well aware, I'm just setting the record. I'm not trying to insult anyone's intelligence. Public defenders are not fungible. I am new to this case. This is a very in-depth case. The state has adequately provided me with the discovery, which includes EMS as well as hospital records. There's a lot of them, Your Honor, and they are above what I know in terms of what's contained in them. I'm not asking to go on a fishing expedition. I can pre-draft my questions and share them with Ms. Creamy ahead of time. I just want to better understand what the witnesses are going to testify to in terms of the medical records, especially in light of the court's prior ruling I see from a motion in limine about what statements can and cannot come in. In terms of prejudice at trial, Your Honor, I feel in order to give my client his best defense, I need to understand the discovery and evidence as best I can. And in order to do that, I need to be able to speak with the medical providers. I don't believe it's as easy as a phone call, trying to get them in. I believe I'm going to need subpoena power to do that.
And what about the person with the sheriff's office? You've got Jonathan Corwin listed.
Mr. Corwin, to my knowledge, is the individual who placed my client under a Baker Act. He was the officer involved with that, so that is the direction I'm going with that. I probably could have a phone call easily with Officer Corwin. I just wanted to give him the same respect that I'm giving the other witnesses.
Did he not prepare a report?
He did prepare a report, Judge, but in terms of the Baker Act, it does not go very in-depth to the details of that, just that it was done.
Mr. Stewart?
Judge, with regards to Officer Corwin, he's the arresting officer. There's a report, there's a video, so I don't think it's necessary that he needs to be deposed. As to some of the other witnesses, Dr. Crandall and Dr. Lamos were previously on our witness list, but my understanding is we filed notices of deleting them from our witness list. The other witnesses Ms. Armpriester is seeking to depose are just individuals who's were involved with the medical treatment at the hospital, but I believe they're what they did is detailed in the medical records. And I guess the other issue is, Judge, this case was previously set for trial. And I believe at the last court appearance, or one of the last court appearances, my notes indicate May 6th pretrial, but we had asked for a continuance because I think we had a witness issue, but the public defender's office had asked to set the case for trial. So it seems late, and Ms. Armpriester, it seems like her the thrust of her argument is that she wants to better understand the discovery, and that's why she needs to do depositions, not necessarily because there's any specific issue or witness that has not provided any information. And I don't think that's a basis for depositions at this stage of the game, especially.
Any reply?
Yeah, they can't speak for what other attorneys did or didn't do, what they said, how they said it. I can only speak for me. And based on what's contained in the records and what the state still is able to use despite motions in limine, it's not just so that I can better understand, it's so that I'm adequately prepared of the witness's testimony.
Is this the one where Mr. Cabrera and Ms. Woodley and I went through the records and determined what could be excluded and what could be, or I guess what would be excluded?
I believe that went through on statements, not the records. And I did reach out to Madam State about how these records would be impacted in light of the motion in limine. And our understanding was that the motion in limine ruling did not apply to these.
All right, based on the arguments today, as well as everything else that's gone on previously in this court file, the court's going to deny the defense's motion to depose state's witnesses. Can you prepare a proposed order, Ms. Armpriester? Okay. And we're currently set for pretrial Thursday. So we'll leave it set there.
Can we handle the pretrial now?
We can if you want to waive your client's appearance.
I would like to.
Is that all right, Mr. Stewart, with you if we handle the pretrial today, or?
Well, if we're going to set it for trial, then I don't have that information.
Okay. Ms. Armpriester says she's not setting it for trial.
I'm going to seek a last continuance
For what purpose?
so that I can go over these records myself with Mr. Lehman. I believe that's
Let's leave this set for pretrial for Thursday. Okay. So we'll leave it set for Thursday. Okay. All right. Any other cases, Ms. Armpriester?
I don't believe I did, but
Okay. I don't see any others either.
after I draft this order, maybe.
You may. Thank you. All right. Let me go to Ms. Human via Zoom. Good morning.
Good morning, Your Honor.
Thanks for popping in early today.
Of course, this works out great. I'm here on behalf of Darren Prizzy, 20 CT 1397.
Okay.
And as Your Honor may recall, he pled no contest to reckless driving as we had a jury practically picked and received 6 months probation. He's current on everything and has completed all the conditions of his probation. He's asking for an early term.
Right. Does the state have any objection?
No, I don't. Probation did reach out to us and they verified that he's completed everything. So.
Okay. I'm getting a nod yes.
Okay, good.
All right. Defense's motion for early termination of probation is granted. Ms. Human, we email a proposed order to my judicial assistant?
I believe I already did.
Okay, very good.
Thank you very much.
Thank you. Have a
Thank
good
you,
day.
Mr. Stewart.
I'm showing we've got one more at 10 and one at 11. I did reach out to, or my office reached out to Mr. Durga to see if he could appear early.
My pen started to run.
Okay.
So you may want to date it yourself.
All right.
Judge, if it turns out I am needed or a pro se individual,
We should be good. We don't have any other pro se's on the docket.
I'll be at my desk so I can hop on the Zoom if necessary.
Okay. All right. Very good. Thank you, Ms.
Can you let
Armpriester.
Ms. Romanelli know my new extension? There is a phone issue.
Yeah, sure.
It's 8326.
All right. Very good. I'll let her know.
Thank you.
All right. Thank you. All right. Guess we'll be in recess until Mr. Verderamo or Mr. Durga joins us.
Are we gonna,
Or we just log back on at 10.
10 o'clock? Okay, will do. Thank you, Judge.
Good. Thank you. All right, good morning, everyone. We're back on the record for criminal motion hearing docket this morning. We've got 2 cases left. Let me go ahead and take Mr. Durga's case. This is Tristan Balderas, case number 17 MM2680. Good morning, Mr. Durga.
Good morning, Your Honor.
All right, I believe this is defense's petition to seal.
Correct, Your Honor. The petition, certificate of eligibility, affidavit have been filed with the court. I have not received an objection from the state, and I did mail, and it was on Friday, a proposed order, which I have already sent to the state, and the $42 to the court, to the clerk.
Okay. You mailed that to the clerk?
I mailed the 42 to the clerk and the proposed order to your chamber. I did send copies of that order to the state.
Okay. All right. Does the state have any objection to the seal?
No, Your Honor.
All right. Petition to seal is granted. Madam Clerk, I know we haven't received the $42 yet. Do I need to hold the order until you receive it?
I'm not 100% sure, but I can put in the minutes
Upon receipt? Okay. All right, so that's what we'll do. Mr. Durga, upon receipt of the $42, the court will issue the order. All right.
Sounds good, Your Honor.
And actually, Mr. Durga, if you want to go ahead and email that order to my judicial assistant in Word format, we're doing everything electronically now, so that'll probably be easier for us. She'll probably be requesting that anyway if you don't go ahead and send that.
I will do that. Thank you, Your Honor.
All right, thank you, Mr. Durga. Thank you for joining us early.
Thank you. You have a great day.
Thank you. All right, let me go to Mr. Carney. Good morning.
Good morning, Your Honor. I have Brian Berber on the law behalf of Campbell Act 20 CT 327 here. Motion for early termination of probation.
All right.
Laid out the motion, but she's completed over half the term. Successfully completed all the conditions, and we're requesting that she be terminated.
All right. Is that correct? Has she completed all conditions?
Yes, Your Honor.
All right. Very good. And state any objection?
No, Your Honor.
All right. Defense's motion for early termination of probation is granted.
Thank you, Judge.
All right. Thank you, Mr. Carney. I am signing the order now. And I believe that completes the docket.
I think so, Judge.
All right. Anything else from you, Mr. Stewart?